has repeatedly sued the federal government for $230 million for the judicial search warrant at Mar-a-Lago, which was perfectly lawful and was never struck down. But now he's suing the IRS for $10 billion. He's suing the IRS for $10 billion, which I think is around 80% of its annual budget, because his tax returns were leaked. And they were illegally leaked by a private contractor who actually is in prison now, Charles Littlejohn. But he wants $10 billion. Now, I want to ask you the question of whether you think it would violate the Domestic Emoluments Clause for you to settle that $10 billion case or any of the other claims that the president has made against the government. He himself has remarked, it's interesting because I'm the one that makes the deal, right? And he says, I kind of have to work it out with myself. Do you think it would violate the Domestic Emoluments Clause for the president to work out a deal from people who are his subordinates under his unitary executive theory to get money in one of these cases?
I'm not going to discuss pending litigation. Okay,
so theoretically you're saying because his privacy rights were violated in that tax case, and they were. I'm with the president on that. I mean, his Mar-a-Lago thing is ridiculous, but there's no doubt that his tax returns, despite the fact that he promised to release them, despite the fact that every other president released the tax returns, he suffered embarrassment when it showed that he hadn't paid taxes for several years, and he had a right for that not to happen. Now, I want to turn back to the Epstein survivors, because President Trump may have been a little bit embarrassed by the release of those tax returns. How much do you think the claims of these survivors are worth? As the good congressman from Kentucky just pointed out, there were lots of survivors who had decided, for reasons of their own, never to release their names. That determination was represented to people in Congress, and we built it into our federal law that their names could not be released, and yet you published their names, their phone numbers, their addresses, personally identifying information. If Donald Trump can get $10 billion, theoretically, from the Department of Justice, how much should these people get for a far worse violation of their privacy rights and a far greater danger established to them in their lives?
Do you even know who Chase Mulligan is? You're so obsessed with, you don't, do you?
I'm going to teach you the rules again. You're the Attorney General of the United States. We have rules here.
You're obsessed with him.
You're the Attorney General of the United States.
You're obsessed with Donald Trump. You have Trump derangement syndrome.
Mr. Chairman, I'd like my time restored. I'd like my time restored.
In your district. In your district, and you don't even know about it, about keeping children safe from online predators.
Time belongs to the gentleman from Maryland. The gentleman can proceed.
Yeah, and I want the whole country to look at this, because this is the Attorney General of the United States, whose job is law enforcement. We've never had a witness who has misunderstood our rules and been unable to conform his or her conduct to our rules before. We have only 5 minutes, and so we use our time to ask you specific questions.
How long are you giving me to answer?
Excuse me, I'm not yielding to you right now. I'd like that second restored too. So, Ms. Bondi, the way it works is we ask you a question, and you answer it, and if you go off on a wild goose chase, another tangent, you start reading statistics, or you start talking about stuff going on in our district, and by the way, I invite you to my district. Come to my district, but that's not what we're here to do today, okay? So, and you do that, then we're allowed to say we reclaim our time. At that point, you have to be quiet. You have no choice. You have to be quiet. So I hope you understand the rule of this point. Now, here's what I want to ask you. You're in law enforcement. We've seen all kinds of evidence of crimes. And when we go over to the Department of Justice for the 4 computers for every member of Congress, we see more evidence of crimes. Will you create a joint task force of the Department of Justice and governors and state attorney generals and district attorneys across the country to investigate the crimes that have taken place against these victims and more than 1,000 like them? The DOJ is not doing its job. Will you create a task force with state and local law enforcement to make that happen?
Gentlelady can respond if she wants to.
Thank you, Chairman. He called Chase Mulligan a wild goose chase and didn't even know who he was. He is a defendant in your own district who preyed on girls.
Mr. Chairman.
Well, you know what? If he were part of the Epstein investigation, you wouldn't do anything about it.
Online chat rooms. And
But that politeness didn't last long. He quickly pivoted to Article 2, Section 1 of the Constitution, the Emoluments Clause. It strictly limits what a president can receive while in office, capping it at their official salary with no extra money from the federal government allowed. Raskin pointed out that President Trump stands out as the first in history to repeatedly sue the very government he leads. One major case involved a $230 million claim tied to the Mar-a-Lago search warrant. But the big one grabbing attention was the lawsuit against the IRS for $10 billion, roughly 80% of the agency's annual budget, over leaked tax returns. Those returns have been illegally disclosed by contractor Charles Littlejohn, who is now serving time in prison. Reports highlighted how the leaks caused embarrassment, especially since Trump had once promised to release his taxes like other presidents, only for them to show years without paying federal income tax. Raskin questioned whether settling such a massive claim under Bondi's watch would cross constitutional lines, especially with Trump's own comments about having to work out a deal with myself under the unitary executive theory. Bondi declined to discuss pending litigation, sticking to protocol, but the exchange highlighted the tricky conflicts that arise when the executive branch sues itself. That privacy violation angle opened the door to something even more charged. Raskin turned to the Epstein survivors, asking how their claims stacked up. After all, if the president could pursue billions for his tax data being leaked, what about the women whose names, phone numbers, and addresses ended up in the public Epstein files? Federal law had been designed to protect those who chose not to come forward publicly. Yet the releases under the current DOJ included personally identifying details. Survivors described the fallout as devastating. Renewed threats, harassment, lives upended. Raskin pressed Bondi directly. If one powerful figure gets massive compensation for embarrassment, how much do these victims deserve for far greater dangers to their safety? The tension escalated when Bondi pushed back on specifics, leading Raskin to reclaim his time multiple times. He reminded everyone of the rules in these hearings. 5 minutes per member, answers to the point, no filibustering on tangents. You have no choice, he stated firmly. At that point, you have to be quiet. Bondi fired back, referencing Chase Mulligan, a predator in Raskin's own district who had preyed on dozens of young girls through online chats. She accused Raskin of dismissing real local crimes while obsessing over national figures. Raskin shot back that if Mulligan tied in a broader Epstein-style networks, action seemed lacking. The back and forth turned chaotic, with claims of embarrassment on both sides and the chairman stepping in as time expired. This hearing didn't happen in isolation. It reflected months of controversy surrounding the DOJ's handling of Jeffrey Epstein-related materials. Under congressional pressure for transparency, millions of pages, videos, and documents have been released. Yet critics, including survivors and their lawyers, slammed the process as sloppy at best. Some files contained unredacted names and contact info despite promises of protection. Others were pulled down after public outcry because they exposed victims who had stayed anonymous for years. Attorneys for the survivors called it one of the worst privacy breaches in recent memory, leading to class action lawsuits against the DOJ and even tech platforms spreading the information. Rumors continue to swirl online about why certain powerful names appear shielded while victims bear the brunt. Reports claim that while transparency was the goal, the releases sometimes protected perpetrators more than they delivered full accountability. There's been a lot of discussion about incomplete prosecutions, no major new indictments of high-profile associates in recent waves, and questions about whether political influences play a role. Bondi and her team defended the efforts as thorough under tight deadlines, but Democrats like Raskin labeled it a cover-up that betrayed the principle of justice for all. Raskin's questions went beyond the immediate clash. He challenged Bondi on creating a joint task force. This would link the DOJ with state attorneys general, governors, and local prosecutors to dig deeper into crimes against Epstein victims and to more than 1,000 others affected by similar patterns. Evidence from congressional reviews of DOJ systems reportedly showed additional signs of wrongdoing that weren't being pursued aggressively enough at the federal level. Raskin argued the department wasn't doing its core job on these fronts. Bondi countered by highlighting other priorities and past difficulties with witnesses, but the exchange underscored a bigger divide. One side demanding faster, broader action for victims, the other pointing to procedural limits and ongoing work. The hearing also touched on broader DOJ oversight issues, including accusations that the agency had become too focused on certain political targets while letting others slide. Grand juries rejecting some proposed charges added fuel to claims of overreach or misdirection. As details from the Epstein files continue to surface in pieces, the public reaction has been intense. Survivors have spoken out about feeling degraded and re-traumatized, with some attending hearings to press for better protections. There's growing talk in legal circles and online forums about the balance between releasing information for accountability and safeguarding those who suffered the most. Speculation persists that full unredacted access could reveal more connections among influential figures, but risks to victims remain a major concern. On the Trump lawsuit side, legal experts debate whether the $10 billion claim holds up, especially with the president overseeing the agencies being sued. Trump has mentioned potentially donating any winnings to charity, but the optics of a sitting leader pursuing such damages raise eyebrows across party lines. These stories intertwine in ways that keep fueling debates about fairness in the system. Who gets heard, who gets protected, and who faces consequences. The back and forth in that committee room captured something larger about Washington today. Personal security threats are real for lawmakers on all sides. Constitutional limits exist for a reason, yet enforcement feels selective depending on who's in power. Privacy breaches hit hardest for those without influence, while big players leverage the courts. Bondi's tenure drew sharp scrutiny here, with some later reports noting internal shifts at the DOJ amid the fallout. Raskin framed it as siding with perpetrators over victims in certain cases, a charge that resonates in an era where trust in institutions is low. Yet defenders argue that releasing files, even imperfectly, advances public knowledge over secrecy. What stands out most is how quickly the hearing devolved into rules disputes and personal accusations. Raskin teaching the Attorney General the hearing etiquette. You have no choice but to be quiet, highlighted frustrations with evasive answers that have plagued past sessions too. Bondi pushed back strongly, refusing to yield ground on her decisions or knowledge of every local case. This kind of drama drives home the human element in high-stakes politics. Egos, interruptions, and moments where protocol clashes with passion. For those following Epstein developments, the privacy failures add another layer of distrust. Victims who trusted the system to shield them found their details online, searchable and shareable, leading to real-world harm. Lawyers have documented cases of renewed trauma and safety fears directly tied to the releases. Looking closer at the tax leak precedent, Little John's actions affected thousands, not just Trump. The lawsuit tests theories of government liability for contractors and massive statutory damages. It also spotlights the irony, demands for privacy from one corner while pushing transparency in others. Rumors suggest settlements could happen quietly, given the unique dynamics of the executive suing its own branches. Neutral observers note that while the emoluments concerns are worth debating, actual violations would need clear evidence beyond speculation. Similarly, on Epstein, calls for task forces aim to empower states where federal action lags, potentially uncovering more in chat rooms, networks, and hidden records that span years. This hearing leaves plenty to consider. It exposed cracks in how oversight works when tempers flare and time is short. It raised valid points about victim protections in massive document dumps. And it kept the spotlight on whether the DOJ under Bondi balanced transparency with safety effectively. As more files potentially emerge and lawsuits play out, the conversation won't fade. People on both sides of the aisle are watching to see